Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer with Samfiru Tumarkin LLP. I'm located in Toronto. It's great to be back with you guys. I've hosted many of these question and answer sessions, and I really enjoy having the opportunity to educate you on your employment rights. It's a very important thing, and our firm cares a lot about everyone knowing what their rights are within the employment world, because that impacts Canadians on a day-to-day basis. As you know, we host these Q&A sessions multiple times every week across our offices. As I said, I'm in Toronto. We have offices in British Columbia and Alberta as well. And like I said, our goal is to get your questions answered. So please don't be shy, ask your questions, and I will try to get through as many as I can today. As I normally do, I'm going to start off with talking about an important topic in employment law. And what that is today is that Canadian companies, we're seeing a trend, and research is showing that Canadian companies are filling positions by retraining existing employees as opposed to hiring new employees. Of course, this doesn't go across the board, but there is a trend of that where employers want to retrain and reskill those current employees to fill the positions and the needs of a company, as opposed to saying, employees, stay in your current job, we have a certain need, and we're going to hire external new employees to fill those positions, those needs. And the reason for this is budget constraints. Usually, it's cheaper for a company to retrain current employees and have them perform new jobs or slightly different jobs, as opposed to hiring new employees. But what does that mean for you? Very important that everyone understand that if your employer wants to retrain you, wants to offer you a new position within the company, that might be something you want. That could be something you desire. It could come with advancement within the company. Maybe you want to learn new skills. You want to perform a new job, and that's excellent. But some of you may not want that. You might be very content with your current job and the current status quo, and you don't want a new position. You don't want to be retrained. And if your employer is forcing you to retrain and to therefore fill a different position, that is an employment law issue. That is what we call a constructive dismissal, where your employer is implementing substantial changes to the terms of your employment. In this case, it would be the position. And you don't have to accept that. And if you don't accept it, you're entitled to your full severance pay. Okay. Now, a key thing is that the changes have to be substantial. So if your employer just wants to add, a task or two and train you on those couple of tasks, and otherwise you perform your job as normal, that may not meet the standard that's required for it to be a constructive dismissal, because those changes aren't substantial enough. However, if 50% or more, and that there's no set percentage, I'm just giving an example, 50% or more of your duties are changed as a result of the new position and the retraining you'd have to do, then that would be a constructive dismissal. It could also be that your pay is different or your hours are different. All of those things are changes to the terms of your employment. And if they're significant, you don't have to accept it, and you can seek your full severance pay. We deal with this all the time. I've had many cases like that. And like I said, sometimes it's something that an employee wants. Sometimes it's something that an employee does not want. And so it's important to know, especially as these trends grow in Canada, where there's more retraining of existing employees, you don't have to accept those changes to your employment if there are changes that come along with the retraining. Okay, so that's the important topic that I want to start off with today. If you have questions about what I spoke about, please feel free to post them in the chat. We have many questions already in the chat, so let's delve into those. We have a question on YouTube from Sir. Our employee manual says that we can get education covered by the employer. I've tried to do this and the employer has refused, saying it is suspended. is the employer required to provide this since it is part of a signed agreement? Yes. If you have a signed agreement saying that a certain type of educational advancement, or could be anything, it could be an expense related to your education, if that's supposed to be covered and your agreement says so clearly, then it's a breach of your agreement if your employer does not cover those expenses related to your education. And that would be a problem. You should absolutely contact us. You can contact us at help@employmentlawyer.ca, and we'd be happy to assist you with this. Easy question. I answered it, and if you have any follow-up, please post it in the chat. Moving on to another question on YouTube from Ahmed. As per the ESA for everyone is the Employment Standards Act. In Ontario, that is the minimum legislation, the minimum standards legislation that governs people's employment. So Ahmed says, as per the ESA, the Employment Standards Act, the severance is a maximum of 8 weeks. If that's the ESA's guideline, why do you say it could be months? Excellent question. So the Employment Standards Act is, like I said, it's a legislation that provides your minimum rights. You cannot get less than those minimum rights, even if you wanted to. Your employer would not be able to give you less than that. So if you are entitled to 8 weeks of pay, according to the Employment Standards Act, that is the minimum amount. You can't get less. However, you could get up to 24 months of severance, 2 years of severance pay, because many times your severance is not going to be dictated by only the Employment Standards Act. It will also be dictated by another area of law. And the way we calculate your severance, that could be up to 24 months, is by assessing various factors. Those factors are your age, your length of service, your position within the company, and generally the availability of similar employment opportunities for you in the job market. So, like I said, the ESA is the minimum standards, and you can get much more than that. As you see on the screen, we have a tool called the Pocket Employment Lawyer. You can find it at pocketemploymentlawyer.ca. As part of that tool, we have what's called a severance pay calculator. The severance pay calculator is a free and anonymous tool, and it will ask you questions exactly related to those things that I just spoke about. What is your age? What is your position? How much do you earn? How long have you worked for the company? And right away, the severance pay calculator will determine what the range is that you are entitled for your severance. What range of severance are you entitled to given your specific factors? Okay. Amazing tool. Like I said, free and anonymous. You can use it whether you've been terminated. You can use it whether you haven't been terminated. You can tell your friends and family about it. Everyone is free to use it. You can use it as many times as you want. And that will let you know what your severance entitlements are. In most cases, people are not going to only be entitled to their minimum amounts according to the Employment Standards Act. You're going to be entitled to often months of pay, as Ahmed notes. So very important that Ahmed asked that question, and I had the opportunity to explain to everybody what most people are able to get for severance pay. Okay. Let's read another question on Facebook from Yalla. My wife was fired 1 hour after informing her manager that she is pregnant and requested mat leave for January. They said that they are restructuring, and this was the reason for her termination. She was there for 2.5 years. They offered her 22 weeks and said that she has to sign back by September 4th. We want to speak to a lawyer, but will we lose the offer if we don't sign in time? Okay, Yella. This is an amazing question. There's a lot packed into it, so I'm going to break it down. So let's deal with your last main question head on. If you don't sign back by their date, September 4th, you will not lose the offer. Okay? In 99% of cases, you're not going to lose that offer. Your employer is using a pressure tactic so that you will sign back by the deadline and accept the 22 weeks that they want you to accept. Okay, you may be entitled to more, or your wife might be entitled to more than 22 weeks. I deal with termination documentation. I have employees coming to me saying they've been terminated every single day of my legal practice. And there's almost always a deadline within a termination letter. And the employer says you have to sign back by X date. Usually it's a week. Sometimes could be less, could be a little bit more than a week. And if you don't, you're going to lose this excellent offer, right? Usually it's not actually an excellent offer. And almost always the deadline is not a real deadline. It's a pressure tactic, like I said. So you do not have to sign back by then. You absolutely should speak with a lawyer at our firm, and we will help you determine whether the severance offer is in fact a good one. And we will advise you whether we can assist you in obtaining more severance. And you should note that you have 2 years, according to the law, to pursue your severance entitlements. Not 1 week, not 10 days, not 2 months. You have 2 years. So take your time. It is important to act quickly because you want to lock in a good severance offer as quickly as possible. However, you don't have to feel the pressure of the deadline that your employer is imposing on you. Moving on to other aspects of Yella's question. If your wife was fired 1 hour after informing her manager that she's pregnant and requesting mat leave, that is very clearly a human rights issue. Sometimes it isn't as clear cut as this. It isn't that you're fired 1 hour after. It could be a few days. It could be a week after you inform your employer that you are expecting a baby and you need mat leave. But in either case, it is a human rights violation. You would be entitled to human rights damages, compensation, on top of the severance pay that you'd be entitled to. So, Yella, I really hope that your wife has not signed back this offer and doesn't do so before September 4th. She should call us. We will arrange a consultation with her. Contact us at help@employmentlawyer.ca, and we will ensure that she obtains the entitlements that she deserves. Let's move on. We have a question on YouTube from Kevin. What is considered a typical time frame for HR, human resources, to respond back to a severance package email related to negotiation? It's a great question. It varies significantly. Sometimes I have HR respond to me within the day, sometimes a few days, sometimes it could be a week or a bit more. We are going to be on top of it. We're on top of our client's negotiation. We will keep you informed throughout the entire process, whether we've received a response, whether we haven't received a response. If we're required to follow up with HR, you're going to know about it. We never keep our clients in the dark, and we will follow up and ensure that we get you the severance that you're entitled to. But there's no exact time frame in which HR can respond, or the lawyer representing the company could respond. It could be a few days, it could be less, it could be more. Okay, let's move on. We have a question on Facebook from Irmala. I hope I pronounced that correctly. When you say how long, is it the time you become full-time or the year you start with the company? Okay, so I think what Irmala is asking about is when I talked about your severance pay being based on, one of the factors is based on your length of service. Irmala is saying, is it the time you become full-time or is it the year you start? So it's the year you start. You could have worked part-time for 10 years and then full-time for another 10 years. That would still be considered 20 years of service, not just 10 years of full-time work. Okay, so the part-time years or months are absolutely included in determining how long you've worked for the company and therefore how much severance you're entitled to. Excellent question. If you have a follow-up, please let me know. Nompak on YouTube, you should be able to post your question. If you can't, then contact us at help@employmentlawyer.ca and we'll assist you. But try posting your question and I'll get to it. Okay. We have another question on Facebook from Renee. I have been with the company for 7.5 years. Last year, I went on maternity leave. Approximately 2 weeks after I left for maternity leave, they sold the business. I had no idea this was happening. Now I'm trying to return to work, and the new owner is not answering if he's giving me my position back or if he's giving me any position at all. Well, absolutely, Renee, you've been terminated. I can tell you that for sure. So if you're on maternity leave, you are entitled to job protection. According to the law, you still have your job for either 12 months or 18 months. According to the legislation we talked about earlier, the Employment Standards Act. And if you don't have a position when you return to work, whether it's because your employer sold the business to a new owner or for any other reason, then you've been terminated. You're entitled to your severance pay. Absolutely. Okay. If the employer is not answering, the new or the old employer, then just contact us and we're going to help you get the severance you're entitled to. Again, help@employmentlawyer.ca. And again, as you see on the screen, at employmentlawyer.ca, we have a wealth of information online on all of these topics: severance, constructive dismissal, termination while on maternity leave, all the things we've been speaking about. We have so much information online. We want to answer your questions here, so please feel free to post them. But again, after the Q&A session, if you want to learn more, go at employmentlawyer.ca and you can learn more about all of these topics. Okay, we have a question on YouTube from Ro. I worked for a well-known retailer for 17 years. Full benefits and probably one of the highest paid cashiers. They accused me of stealing, which I didn't, and then they didn't schedule me for 2 weeks. They questioned me again the second time, made me sign papers, and then told me to leave. Do I have any recourse here? It's a very good question. I don't know what papers you signed, so I'd have to know more details about what papers you signed. If you signed documentation saying that you received some sort of severance, that could be a binding agreement. You may not be able to obtain more. But presuming that you didn't sign such an agreement, you should be entitled to your severance pay. You do have a recourse. If they accuse you of stealing and you didn't, then what might have happened is they terminated you for cause. And this is a very big topic, and let's address it now. Termination for cause is when your employer takes the position that they're terminating your employment and you're not entitled to your severance pay. That's the employer's position. We're letting you go with no severance. Okay? Most of the time, when an employer does that, they're not actually legally correct in withholding their severance from you. And we will help you obtain your severance. Just because your employer says that they're terminating you for cause does not mean that there actually is cause for termination of your employment according to the law. Sometimes there is. If you've engaged in theft, if you've actually stolen from the employer, if you've engaged in fraud, various egregious behaviors, then yes, there likely would be cause for termination there, and your employer is in the right to let you go without severance. However, context matters. Each case is different. We deal with cases of termination for cause all the time, and what I could tell you from my experience is that often there is not actually cause for termination, and we will get you the severance pay that your employer has withheld from you. So Ro, in your case, if they accuse you of stealing and you didn't, then you should get your severance pay if they've withheld it from you. So contact us at help@employmentlawyer.ca, and we will arrange a consultation with you, and we'll discuss all the details of what you sign. We'll review the documentation, and we will we'll check to make sure that everything is in order. Okay, we have about 10 minutes left. Before I dive into more questions, I want to raise a topic similar to the one I spoke about at the beginning of the session, which was about constructive dismissal, reskilling or retraining employers wanting to do that instead of hire new employees. They want to retrain their current employees and implement changes to the employees' positions. So now what we'll talk about is for new hires, right? For people who are starting at a company for the first time, or for people who've worked for a company but are now being offered a new employment contract. what are the things you have to know? So if you're starting at a company for the first time, you get offered an employment contract, which most people do. Or if you've already worked for a company for some time and the employer says, hey, we want you to sign this new employment contract, what do you do? So first of all, you call us right away. Very important that you do that. There's a reason why the company wants you to sign an employment contract. They want to have the details of your employment in writing. But what they also want is usually to limit what your rights are. And an employer can do that if they do it properly in a contract. So if you would normally be entitled to up to 24 months of severance, as we've spoken about, it could be that if your employer does it correctly, they can limit your entitlements, but they have to do it correctly. And you should know if your employer is trying to do that. So if you're offered a new employment agreement, we'll review it. We'll let you know what is being limited and what your rights are according to the agreement. And we can help you negotiate certain terms of the employment contract to ensure that they actually are compliant with what your rights should be. And it's a desirous employment relationship for both parties, not just the employer getting what they want, but you should also have a say in the process, a say in what terms will govern your employment. Okay. We'll move on from that. If you have questions about it, please post it in the chat. Okay, we have a question from Annie on Facebook. Yesterday, I was given a proposal to either accept a temporary layoff or cut ties and take severance. I haven't signed it yet. I wanted to get some clarity. I have been at the company for just over 5 years. My salary is $55,000 per year. My title is Business Development Manager. I'm 37. What should I be offered? Okay. So first of all, let's deal again with your question head on. And then what I want to talk about is a temporary layoff. So if you have been offered a layoff or cut ties and be terminated, what that means is to be terminated and take severance. And your factors, the factors that we talk about that determine how much severance you're owed. So Annie's factors are that she's worked there for 5 years. She has a salary of $55,000. She's a business development manager, and she's 37. So what you should be offered is in the range of 5 to 8 months of pay, I would say. Again, there are some factors that are very much in your favor. You have 5 years of employment. That's a pretty solid term of employment. 37 is considered relatively reemployable. You're still young. You can easily find a new job in most cases. And so I'd say between 5 and 8 months would be a good range for you to fall in terms of severance. Usually your employer will not make that kind of offer to you from the get-go. They could offer you 2 weeks. They could offer you 5 weeks. You would be minimally entitled to 5 weeks of pay according to the ESA, which we talked about earlier. But in most cases, you're going to be entitled to much more than that. Okay, so excellent question. Now, a temporary layoff. A temporary layoff is something we should speak about. It happens quite often. And what that is when your employer says, we are laying you off temporarily. In Annie's case, they said, we can cut ties, we'll terminate you and offer you severance. But in most cases, if they're laying you off temporarily, they're not offering you severance. They're saying that you're laid off and we'll let you know if we have work for you. And sometimes the employer gets back to the employee. Sometimes they don't. If they don't, you've been terminated. If they don't get back to you within a certain time frame, you've also been terminated. That time frame is usually 13 weeks. And so if you don't hear from your employer after you've been laid off within 13 weeks, you can assume that you've been terminated. In some cases, it's a bit longer than 13 weeks. Each case is different. But what's important to note is that if you've been laid off, you usually can fight it right away. You don't have to wait the 13 weeks or more to determine whether you have been terminated and sit around and doing nothing to see whether you have a job. You can fight it right away and obtain your severance pay, because a temporary layoff is another excellent example of what we've spoken about throughout the session of a constructive dismissal, where the employer is implementing a change to the terms of your employment. In this case, the change is that you're not going to have a job right now. You're being laid off temporarily. That's not something you agree to. And so you don't have to accept that change. And if your employer is forcing you to go off temporarily, you can say no, and you could obtain your severance pay. Now, very important again, going back to employment contracts, very important that we review your employment contract if you've been temporarily laid off, because it could be that your employment contract allows your employer to lay you off temporarily. Often it doesn't, but sometimes it does. And so we need to see that employment contract. If you've been laid off, we'll arrange a consultation, we'll review the contract, let you know what your rights are. Can you fight this layoff immediately? Should you wait the 13 or more weeks to fight it, to see if you're getting called back to work, or whether you could obtain your severance? Okay, so I hope that answers your question, Annie. We have time for a little bit more. So let's deal with the question from Carmen on YouTube. I'm handing in my resignation, and my final day will be September 30th. Our fiscal year end is September 30th. Will I still be able to receive my bonus for the year? It usually is paid out in December. So in this case, yeah, you should be entitled to your bonus. If you've worked through September 30th and the year end is September 30th, you've worked and earned the bonus. So just because they don't pay it out right away and they wait till December, you are entitled to it because you worked for it. Again, I have limited information here just from your question alone, Carmen. I need to see really the terms of your bonus payment. Usually there will be some documentation that spells out what happens if you resign or are terminated. Do you get your bonus? Do you not get your bonus? How long do you have to have worked? But presuming the contract doesn't limit you in that regard, or is silent about bonuses in general, then you should be entitled to your bonus if you've worked for it, and you resign only after the year end. Okay, let's deal with a question from BB Burrows on YouTube. So my employer wants me to move to a lower position. It comes with a pay cut, but provides a discretionary bonus at the end of the year. Would that mean that it isn't a pay change? Do I have to accept the offer, or would I lose my job? Okay, great question. This is an example of a constructive dismissal. If your employer is saying that you are going to get a pay cut in a lower position, the lower position is a change that you don't have to accept. And if it comes with a pay cut, it's another change that you don't have to accept. If the pay cut is nominal, very small, then it may not be a constructive dismissal, because again, it has to be a substantial change. But if it is a significant pay cut, even if it comes along with a discretionary bonus, where you may get the bonus, you may not. So there's still a big change there, because if you don't get the bonus and there's a pay cut, well, now you have severely lower pay. If you do get the bonus, it could be that you don't have such a massive pay cut, but still the fact that it's discretionary is very important. Again, if the pay cut is significant, whether or not there's a bonus involved that you may get, then this sounds to be like a significant change, and it is a constructive dismissal. You don't have to accept it. If you want to, you can. We don't usually advise it, but if for one reason or another you want to keep your job, you want to accept it, that's fine. But you don't have to. You can contact us at help@employmentlawyer.ca. And we could arrange a consultation and determine exactly what the pay cut is and what you'd be entitled to if you don't accept the new position and the pay cut. All right, that's it for today. I hope this has been very helpful. We are back at 1 p.m. tomorrow. My colleague Thielen will be hosting another Q&A. There's some questions I didn't get to. It's amazing. We had tons of questions today. Please join us tomorrow. Ask your questions, and Thielen will do his best to address them. Thank you, and I'll see you soon. Take care.